You're watching news at Prime. Let's get into this conversation now. Magistrate Twanet Olivier, who is presiding over disbarred attorney Zuko Nonxuba's case, has voluntarily recused herself from the matter. News 24 reporting at the weekend that this is because she wouldn't be sufficiently impartial to give a fair decision after watching media coverage of some of the alleged victims. Now, Nonxuba is accused of defrauding millions that were meant for disabled children. The Eastern Cape NPA spokesperson, Luxolo Tyali, is going to join us in a few moments, but we'll kick off this conversation with Judges Matter researcher Mbekezeli Benjamin, who joins us from Cape Town this evening. Mr. Benjamin, good evening to you, and thank you very much for your time. Are these developments disturbing for you, that a magistrate would recuse herself, saying that she is unable to trust herself to give a fair decision, particularly on the accused, after watching media reports, specifically video footage of these children that are disabled and what they have gone through over the years when their lives could have been better if this money was given to their guardians?
Good evening, Mr. Mgambi, and good evening to the viewers. Yes, this development is very disturbing to us. We are worried to hear that the magistrate decided to voluntarily recuse herself based on news reports. There are a number of reasons why we think that it is wrong for her to have done so. First of all, magistrates, all judicial officers, in fact, have a constitutional obligation to preside over all the cases that they have been assigned. They must administer justice without fear, favor, or prejudice. So even if they hear of something disturbing, if that aspect does not affect or doesn't give any rise to bias or a reasonable apprehension of bias, then that magistrate cannot recuse themselves or cannot pull out of a case. And so we are really disturbed to hear that the magistrate, based on simply watching the news, she decided to recuse herself. It is precisely why in South Africa we don't have a jury system, because we exactly want to guard against judicial officers having to be influenced by what is in the news or what they see in the atmosphere. Because if this is allowed to stand, then there is not a single magistrate in South Africa who will preside over a rape case or a case involving violence against children, because it's inevitable that those cases are traumatic. And so we are really disturbed by this development.
There is a body that looks into the conduct of magistrates. It's separate to that which looks at the High Court judges. This specific one for magistrates, it's called the Magistrates Commission. And I have to tell you, I must declare that we did try as a show to get a hold of the Magistrates Commission, but we were simply not successful. It doesn't mean that we will stop trying. Do you think that they should get involved here in this case?
Yes, I suspect the reason why the Magistrates Commission is not taking your call is because tomorrow they are appearing before Parliament, and so they're probably busy with those preparations. But yes, if there is a complaint that is filed by any of the parties involved in this specific case, the Magistrates Commission will have to investigate it. But the better process is for the National Prosecuting Authority to take Magistrate Olivier's decision on review in the High Court. There have been a series of cases in the High Court where magistrates have recused themselves voluntarily. And in those cases, particularly in the Western Cape High Court, there are two cases. One is State versus Lamb, the other is State versus Vermeulen. In both of those cases, the High Court said it was wrong for the magistrate to recuse themselves because there were not enough reasons, so there were not enough substantive reasons why the magistrate should have recused themselves. Because ordinarily, a recusal is asked for by the people involved in the case. So if you as a litigant in a case feel that there is an apprehension or your fear that the magistrate will be biased, then you can bring an application. And that application has to be carefully scrutinized by the magistrate. First of all, the legal test is that there must be a reasonable apprehension of bias, and that reasonable apprehension must be done by a reasonable person. So that is a very high standard for you to get a magistrate to recuse themselves. And so when a magistrate decides to do so voluntarily, it has to set alarm bells ringing, and I do think that the NPA should take this decision on review.
Yeah. I'll ask you during the course of the conversation to comment about what potential witnesses for the NPA might be thinking at this time. But before we get there, I just want to read an extract from this article that was written by Karen Morn of News 24. In it, she writes that her recusal, this is now Magistrate Twanet Olivier, her recusal this week comes after Nonxuba was granted a summary acquittal in another fraud case in the Mthatha Specialized Commercial Crimes Court last year after a previous magistrate convicted him but then died in a car accident before he was able to sentence him. Let's talk about that separate matter. Does that make sense to you, that the court case went on to a point of conviction, but at the time that the magistrate was to hand down sentence, they died in a car accident, and therefore this case was regarded or seen as a summary acquittal?
Look, I can't really comment on the circumstances of that specific case because I just don't have enough information to actually give you a comment on it. But ordinarily, when a conviction has already been made, a different magistrate can still sentence that same person based on the record of proceedings that have been led in the trial. So usually, it happens often that there might have been a conviction already. The trial had already reached the conviction stage, and then it is given to another magistrate because that one magistrate is unavailable. So in this specific case, I think maybe it should have still proceeded. It shouldn't have led to an acquittal. But I can't really give commentary on that because I just don't know enough to do so. But it does go back really to how this process of magistrates and their conduct is done. And in fact, not just magistrates, but all judicial officers. Section 165 of the Constitution is very clear that a judicial officer must comply with the Constitution and with the law. They must deliver judgment without fear, favor, or prejudice. And there are codes of conduct which regulate how judges and magistrates should conduct themselves.
The NPA, the spokesperson that we were meant to talk to before coming to you, Mr. Benjamin, Luxolo from the Eastern Cape, is clear. Unfortunately, he's unable to join us tonight for unexplained reasons. But he is quoted as saying that this decision for the magistrate to step down at this juncture of the case is, quote, frustrating and devastating to the NPA. Let's talk about the witnesses that they would have relied on thus far. This matter has been going on now for about 3 years. Those witnesses, might there still be appetite to come forward? Because as we learn now, this case would have to start anew.
Look, it is a huge worry, Toli. Not only for the witnesses, but for the complainants, the people who have been affected by this. And this is a major case of fraud. It involves 45 million rand. The case has been running for well over 3 years. And this is, again, why it was so important for the decision on recusal to be made very carefully. The magistrate was, even if she had any sort of fears or any sort of reason to believe that she can't bring an impartial mind, the proper process is for her to let both parties know, both the defense and the prosecution, let them know that, look, I've seen this and I feel that I can no longer bring an open mind to this case. And both parties would have argued to say, yes, we agree with you, you should recuse yourself, or no, you shouldn't recuse yourself, considering that this trial has been running for well over 3 years. It involves almost dozens of children who are affected by this, and an amount of 45 million rand. Those are compelling reasons why you should stay in the case and see to finish. And so we are really, really worried about this development. And like I said, we hope that the NPA will take this on review, because it does require the attention of the High Court.
I want to end with this final question, Mr. Benjamin, because you so aptly describe the magnitude of this case, 45 million rand. And this is money that was allegedly taken from children who were born disabled. So the allegation is that he goes to a state health facility and says, this child was born disabled as a result of medical negligence, and therefore you are liable to pay the parents of this child for the duration, basically for the care of the rest of their lives. And they are literally bedridden. I watched that particular insert from Carte Blanche, and we have to mention them in fairness, because they did such a fantastic job of covering this story. One of the children, Mr. Benjamin, and I want to be graphic here purposefully, the mother, because she has to go and work in order to come back and take care of him, she leaves him on the bed, and because the child is disabled, they can't turn, and so it was found that they had developed bad sores on one of his sides. That's how terrible and excruciating this is. It's painful. It was painful to watch. Now, I'm raising this because when Zuko Nonxuba, the lawyer we are talking about, was disbarred as a practicing attorney, the Legal Practice Council had these words to say about him, and I quote, it found Nonxuba was, quote, not guilty of a mere moral lapse, but his conduct is suggestive of a character defect that has severely compromised his integrity. This is someone who just simply couldn't care. Now, to have someone like this roaming the streets still, even though he cannot be a practicing lawyer anymore, but just to have him walk outside as a free man, surely that's injustice.
It is an injustice, and this particular case is probably the most horrific that we have seen in the last few years. But it's not isolated. The Legal Practice Council has released its statistics showing that a lot of attorneys, dozens of attorneys, have been struck off the roll for stealing client money that is supposed to go to victims of medical negligence or police misconduct. And so it is a nationwide problem, and which is why there needs to be accountability in the form of fraud prosecutions, in the form of other civil action that is taken. And so it is incumbent upon all judicial officers, not just in this one case in East London, but in all judicial officers, that they must really follow the law and the code of conduct for judicial officers in how they preside over cases. They must do so with integrity and with the constitutional obligation. They took an oath that they will deliver justice without fear, without favor, and without prejudice. South Africans have an expectation that they will do so in all cases. So in this case, it is an injustice that the magistrate has decided to recuse herself in this way.
Well, I want to bring up two quick cases, Mr. Benjamin, before I let you go, now that we are unable to have the NPA. And it's not about the NPA. This is now an overall judgment on the judicial system, basically the judiciary. In a few minutes' time, I'm going to talk to Gugu Lowry. He writes this weekend that it's time for Vodacom to end this 25-year battle against Nkosana Makate. They have lost 9 times, and there does appear to be a clear verdict that says you must pay up. And he says, if the courts continue to allow for this to happen, then the public is going to lose confidence in the judicial system. I wonder if you agree or disagree with him.
Look, as Judges Matter, we are also concerned by how long cases are taking. And we are particularly concerned by litigants who use what is called a Stalingrad approach, who try to use every single technical legal point to try and drag out the cases. And in fact, in some cases, we're seeing that the litigants, simply to avoid either accountability in the form of civil accountability, where you're required to pay a sum of money, or criminal accountability, where you're supposed to either face a trial in criminal court. Those litigants are using legal procedures to try and delay what is inevitable. You will see it in the numerous appeals, unmeritorious appeals that are taken, and you'll see it in all the disputes that, like you said, in this one case involving Vodacom, where this case has been dragging on, and each point, the Vodacom as a corporation has lost. You mentioned 9 times. Well, we know that there are even criminal cases involving, I suppose, one famous former president who themselves are taking the legal point to court. And we do feel that this undermines the integrity of the judiciary. It does undermine the rule of law and people's faith in the justice system. There are no easy answers, unfortunately, but we do hope that courts will take a much more strict approach in terms of how they grant leave in particular cases and they allow appeals in other cases.
Yeah, and I did say that I would ask about 2 particular cases. Finally, and quickly if you can, the Senzo Meyiwa murder case. It was meant to start today once again, but it's seen another postponement because the lawyer that is meant to now assume the case for accused number 1 who lost his lawyer in December, simply said he had not had enough time within the 2 months that he was given to read 40,000 pages of this particular case, much to the frustration of Judge Rata Mokgwatleng. The kind of stance that this judge should take in that matter, again, to restore this waning public confidence.
Well, in this case, it was quite correct for Judge Mokgwatleng to essentially read the Riot Act to Advocate Mnisi to say he must either come next week Tuesday being prepared for the trial to run, or there must be other means that are devised for the case to run. But this is, again, another common trend where we're seeing people on the day of the court case, they change lawyers, or sometimes the lawyers say that they are not ready. It is unacceptable, and in fact, it is in some ways unethical for a lawyer to wait until 2 months have gone by, 3 months have gone by, and say that they are not ready to proceed in a case that they have been involved for well over 3 years. Again, it is something that unfortunately judges or magistrates are really limited in terms of the kinds of interventions that can be made. But perhaps it is time that the legal profession should also start speaking out in some of these cases, because, like I said, some of these points are because the lawyers involved are taking really unmeritorious points in order to delay proceedings. And that for us is a concern, and the legal community should really start speaking about it.
Mbekezeli Benjamin, a senior researcher at Judges Matter, thank you very much for your time.